Good morning and welcome to the second risk reduction class for August. It's actually a review and with a little more detail in some areas of the live class I did earlier in the month. We're recording this. I'm going to review some of the things I talked about before. I've got a nice PowerPoint to keep it organized, and I'm going to cover a couple of things I did not cover in the previous class, so you'll have a little bit more information. For those of you who did attend the previous class, hopefully the review will be worthwhile to you, but there will be new content as well. If there's any questions, I think Lindsay's going to monitor the chat. My plan is to get through this in the hour, maybe a little quicker, and then answer any questions. As always, if you have any questions, reach out to me. Here are the numbers. I think most of you know how to reach me. That's probably not anything new. Let's take a look at the laws, regulations, and moratoriums affecting landlords, tenants, and realtors. We're going to talk about, once again, I still get a lot of questions about this. I want to see if maybe today, being well organized in this presentation. By the way, I'll make this presentation available in a PDF later today, and Lindsay will do what she does to get it out to everybody. So we're going to talk about selling tenant-occupied properties. When a tenant is in a property, it's your listing and you are trying to sell it. What are some of the considerations? We're also going to look at a quick review of the current laws, regulations, and moratoriums that are in effect. And my goal is not to turn you into property managers, but to give you sort of an overview of a few things you need to know. And again, relative to dealing with your listings if they're tenant occupied, selling your listings that are tenant occupied. I'm going to talk about the financial assistance available to landlords and tenants. That's a very important consideration for your clients to keep in mind. And then finally, again, a review of cash for keys, just hitting the major points that we covered last time. So let's take a look at this. First of all, selling tenant occupied properties. Notices to tenants. And as I've said before, agents, we're going to talk about notices to tenants. We're going to talk about entering a tenant occupied property to show the property. What are the guidelines for that? We're going to talk about entering into a contract to sell a property that is tenant occupied, especially with a special consideration of a contract where the buyer wants to take occupancy of the property and there's a tenant in it at the time of sale. And then finally, entering a tenant occupied property during escrow. And then finally, new owners notification obligations to a tenant. So let's look at those in detail. As I've said before, often agents don't realize this. The seller does not have an obligation or a requirement to notify the tenant that they're selling the property. Now, they're going to have to as a practical matter, but there is no regulation that requires a seller to, number one, notify the tenant, or number two, get permission from the tenant to sell the property. That's the important point, permission. As a practical matter, as I said, you're going to want to notify the tenant, but you do not need the tenant's permission to sell the property. Likewise, you do not need the tenant's permission to show the property. I'm going to show you how that's already been granted. It's as a practical matter, you're going to have to work with the tenant to show the property, but permission is not something required from the tenant. And I'll talk about why that's important in a moment. The seller does need to give the tenant notices before entering the property. That's an absolute certainty. So because of the fact that you have to give notices, you're in effect going to tell the tenant you're selling the property. You're going to tell the tenant you want to show the property, but permission is not what you're seeking. You're simply seeking to give the tenant notice. All right. So the residential lease or month-to-month rental agreement, the CAR Form LR, page 4, contains your the landlord and you as the listing agents right, if you will, contractual right to show the property. The tenant must make the premises available to the landlord or landlord representative, that would be the listing agent, of course, to show the premises to prospective or actual buyers. And it also says that a 24-hour written notice shall be reasonable and sufficient. The code states that the notice must be reasonable and sufficient, and then spells out certain things the notice shall contain. And 24-hour notice is the acceptable notice time frame. Okay, now, so how do you get into a property? Well, you use a notice of entry. An NOE is the typical way to do it. Now, the NOE says that the landlord, and notice it says will be entering the premises at the date and time specified in B below. It doesn't ask for permission. It simply notifies the tenant that you're going to do that. It must be 24 hours notice if you personally deliver this notice, or if you mail it, you have to mail it 6 days in advance of entry. So mailing is probably not a very practical aspect of providing this notice. You state the time, date and time that you're going to enter, and it gives you a couple of options to list. Now, you're entering the property, in this case, not a property manager making repairs or providing services. You're entering the property to show the premises to prospective purchasers. Now, the way to deliver this notice, personal service can be one way to serve the notice. You hand it to a tenant, who's in the property, someone who's on your lease, on your rental agreement. So if you hand it to them, that's personal service. You can do substituted service. You can give the notice to any adult person, that's suitable age, adult person who's at the property and has discretion over use of the premises. So you can do a substitute service, give it to any occupant, not just the one that's on your lease. That's important where maybe a roommate's been added to the tenancy, but not on the lease. Well, you can give it to the roommate, or you can leave it at the door. Now, here's a nice little procedure. You take the notice, you tape it to the door. It must be at the usual point of entry. And you generally, what I recommend is tape it to the door frame, just above the doorknob. Then step back with your cell phone and take a picture of it showing enough of the door that you can identify that as the property, in case you have to prove later that you did in fact post a notice. That the tenant would not get away with saying, gee, I didn't see it. I don't recommend mailing, because you got to mail it 6 days out, and that's a pretty long time to wait. Okay, so the residential lease and month-to-month rental agreement gives you the right to enter the property. The notice of entry is a way to get into the property, but that can be kind of cumbersome when you're showing the property. Every time somebody wants to show the property, you got to run over there and hand them a notice, and that can be a bit of a pain in the neck. It's hard for the agent. It's unfair to the landlord who's trying to sell the property. So there's another form that you can use to show the property, and that's the notice of sale and entry, the NSE. And so looking again at the residential lease, it provides for the use of the NSC. If the landlord has been giving a written notice in the form of an NSC for the next 100, if the tenant, has been given written notice in the form of an NSC, notice of sale and entry, for the next 120 days following the delivery, then the notice to the tenant may be oral to access the property, to show it to actual or prospective purchasers. So the NSC is slightly different than the NOE. I would recommend that you not use the NOE for purposes of gaining entry to show the property. I'm going to talk about in a minute when you do have to use it to gain entry during the escrow. But the NSC, notice of sale and entry, is a perfect form to use to gain entry during the showing period. So taking a look at the form, you are hereby notified the landlord is selling the premises, and pursuant to Civil Code 1954, that's where these notices are formed, are contained rather. For the next 120 days, the landlord or the landlord's agents, and that would include accompanied buyers, may now enter the premises during normal business hours with a 24-hour oral notice. You'd want to keep a log, and voicemail is acceptable. If you deliver a voicemail, leave a voicemail rather for the tenant, that is oral notice. Again, you want to serve this notice initially in writing and then wait 24 hours before the first oral notice. And then thereafter, you don't serve this notice, you just make your phone call. Personal service can be delivered to the tenant, substitute service, any other adult occupant, or left at the entry. Once again, do not recommend mailing it, as that's an extended time frame of 6 days. So when entering the contract to sell a property that is tenant occupied, you got the residential purchase agreement that allows you to do it. I'm sorry, entering into a contract. I got off track a little bit. Entering the property to show it, we've covered. Now I want to talk about entering into a contract to sell the property that is occupied by a tenant. The residential purchase agreement, paragraph 9, deals with possession, as most of you know. If the buyer intends to occupy the property, paragraph 9A or 9B, boxes not checked would indicate the the buyer intends to occupy the property. So in paragraph 9 of the RPA, it says the buyer intends to occupy the property. If this is checked, then he does not intend to occupy the property. And much about what I'm going to say going forward on this subject wouldn't really apply. Or if they check the box in paragraph 9D, the tenant's to remain in possession, again, much of what I'm going to say doesn't apply. My concern is a seller, through their listing agent, is selling a property to a buyer who intends to occupy the property, but at the current time of the sale, there's a tenant in the property. And where mistakes can occur, where problems can arise, is maybe the tenant is given notice even. Maybe the tenant has told you he's moving out. Maybe there's been arrangements for the tenant to be out. If the tenant doesn't physically leave the property, it can be very difficult, time-consuming, and expensive to get that tenant out. Meanwhile, if you sold the property to a buyer who intends to occupy, then you're obligated to deliver that property vacant to that buyer, and you could be liable for any damages the buyer suffers as a result of your tenant not getting out, even though the tenant told you they were going to get out. That would be an action between you and the tenant. The buyer would have an action against the seller, you being the seller or the seller's agent. Actually, you wouldn't be sued, but you'd be sued by your seller for putting the seller in a pickle. I've sold my house to a buyer who intends to occupy, and I can't get the tenant out. Why didn't my listing agent protect me? So look for these two items on a purchase contract if you have a tenant in the property at the time of the sale. It doesn't matter if the tenant intends to get out. People change their mind and they don't do what they say they're going to do. That's unfortunate, but that's common. And if you don't have this box checked, then your tenant has a contractual right to occupy the property. All right. So sell the property contingent upon the tenant vacating the property prior to close of escrow. That gives the seller an escape clause if the tenant doesn't get out. So again, unless one of those two boxes I just reviewed are checked, if they're not checked, then make sure in your counter, if there's a tenant still in the property, don't care if the tenant's going to move out tomorrow. If you enter into a contract today, you could be in trouble if that tenant doesn't move out. You can always remove that contingency, or that contingency will go away when the tenant does move out. But put that on a counter offer. Sale of property contingent upon tenant vacating property prior to close of escrow. Or counter, the tenant shall remain in possession, and then provide a tenant in possession addendum, a TIP. It's pretty straightforward. If you have any help with that, give me a call. It's a pretty easy form to fill out. All right. So entering a property while you're showing the property is one set of guidelines. Entering into a contract once you've located a buyer's identified themselves and wants to buy the property, another set of guidelines. There's yet a third set of unique guidelines, somewhat unique, for entering the property during the escrow. This is important to note. You must use the notice of entry to enter the property during the escrow, not the notice of sale and entry. You know, it's a not well-known distinction. And if no harm, no foul, but if you try to use a notice of sale and entry to gain access to the property once you're under contract, you're really not following Civil Code 1954 or the the lease agreement. The residential or month-to-month lease agreement states that you have a right to get into the property for lenders, appraisers, contractors, people making repairs, other interested purposes, but it doesn't give you the right to gain that access with an NSE. Notice that the NSE notice may be given to show the property to actual or prospective buyers. Now, you could probably get the buyer in with an NSE if they wanted to go in and measure for drapes, but you couldn't legally get the buyer's inspector in because the buyer's inspector is not the buyer, and the NSE is for prospective buyers, not for contractors, not for appraisers, that sort of thing. So you'd want to go back to using the notice, not use the notice of sale and entry, but to use the notice of entry. See, the notice of sale and entry, oral notice to prospective or actual purchasers. Notice what's not listed there: appraisers, physical inspectors, contractors to perform repairs. So the NSE, notice of sale and entry, is only for showing the property to buyers. The NOE, notice of entry, is for gaining access, and not only for buyers, but for anybody else. Hope that's kind of clear. Hope I didn't confuse anybody. Review this when you get the PowerPoint or the PDF, and I think it'll be pretty straightforward. Now, the one notice that a new owner does have to provide to a tenant is the physical address of where the landlord can be served notices. That's in Civil Code. The new owner must do that. I believe it's within 48 hours. Tell the tenant an address that the tenant can serve the new owner. It cannot be a P.O. box. It has to be a physical address. And again, that's for purposes of serving a notice, not mailing a letter. And it can be the address of the property manager. So those of you who represent buyers, give them a heads up. Once you own this tenant-occupied property, you should provide the tenant with a notice of where they can serve notices. They, being the tenant, can serve notices on the landlord. Okay, hope that's pretty clear, and hope that clears up a few of the questions that I get still regarding getting into a property to show it, or getting into a property while you're in escrow. Now, as I said before, let me just touch on this. When you notify a tenant that you're going to be showing the property, I recommend you do not use it. Don't use language that makes it a question. Would it be okay if I come over tomorrow with a buyer to see the property at at 1 o'clock. Well, the good news is that's 24 hours because it's not even 12 right now. So I'm coming over tomorrow at 1 o'clock. But if I say, would it be okay? You suggest to the tenant they have the right to give you permission, or more importantly, deny you permission. And so I recommend you phrase it sort of in a affirmative statement. I'll be showing the property tomorrow at 1 o'clock. Now you pause for a minute, and if the tenant says, 1 o'clock isn't good, Walt, I'm still be in the middle of my nap. As you know, I'm a night worker, and I usually don't get up till about 2:30, 3 o'clock. Could you show it at 3? That's a tenant who understands their obligation to let you in, but it's just not convenient for them. They're not fighting you. They're just trying to, give you some insight, so you can be, thoughtful of their situation. I would recommend you say, sure, 3 o'clock will be fine. And so you sort of do let them give you permission because they're not saying, no, you can't. So that's one way to handle a tenant. Now, as I always say, I don't hear about the nice tenants. I hear about the bad tenants, the troublesome tenants. If you call your tenant and you say, I'll be showing the property tomorrow at 1 o'clock, and they say, no, you can't. No, that won't work. And there's silence. That's a tenant who believes they have the right to give you permission. And more importantly, they probably don't want to ever give you permission. They're not very cooperative. They're not even suggesting, gee, today's not good. How about tomorrow? That's back to the nice type of tenant. Work with that nice tenant. The tenant who just says, nope, sorry. You got to politely tell the tenant, oh, I'm sorry. I didn't mean to suggest I was asking permission. I'm simply notifying you as per the lease and regulations, the law. And you sort of set the record straight. I'm not seeking permission. And you have to be a little more forceful with those types of tenants who aren't necessarily cooperative. All right.
Well, before we move on, Dave Zeman had a question.
Yes, Dave.
He wants to know, can the NSE or the NOE be emailed?
The problem with email is the courts consider email to be mail. So I would be concerned if you email it and the tenant claims they never got it, you're going to have to wait 6 days. If you email it and you ask the tenant to confirm they got it, then yeah, sure. So if you got a cooperative tenant and you email it to them and, hey, could you give me a heads up that you got this? And they email back, yeah, I got it. Well, they can't deny they didn't get service. So I would say, absent a tenant responding to your email, you gotta, it's gotta be personal service. I hope that answers your question. It's probably not the answer you were hoping for, but that's a great question, by the way. But
we have another quick question, Walt.
Yes.
Sissy's wanting to know if the tenant can use COVID as an excuse for not wanting to let people in.
Yes, I'm going to talk about that in a moment. As a matter of fact, they probably can. The courts are going to be say, if a tenant doesn't let you in, what's your remedy? Well, you can attempt to evict them for breach of contract. You can't evict any tenant for breach of contract if it's COVID related. So you're not going to be able to evict them. If you ask the tenant, hey, don't ask, you tell the tenant, I want to show you a property tomorrow. And they say, nope, I don't want anybody coming in my house. I don't like people coming in my house. And they don't ever reference they have a COVID concern. You could evict them for a breach of contract for not giving you access to show the property. The problem is, as you're going to see in a moment, that's going to take several months to perfect. So it's the simple answer is yes, COVID is a acceptable excuse to breach the requirement that the tenant gave you access to show the property. And even absent the COVID excuse, if they don't let you, your remedies right now are somewhat limited. Not a great position to be in if you're a landlord. I'm going to talk about how you handle that in a moment. That answers Sissy's question? I'm assuming it does. Okay.
Yeah, I think it does. And
Okay.
if you're going to touch on it again, I think it will.
Let's review the current laws, regulations, and moratoriums. And this is not to turn you into property managers, but to give you kind of a working knowledge of the situation so you can better serve your seller clients. All right. So let's look at that.
Thank you, Walt. I'm sorry, it was on mute. Thank you for answering my question. But also my question is, if they don't have COVID, they are not affected by COVID, they're afraid of catching COVID from visitors because they have small kids, can they still use that as an excuse?
Yes, that's a COVID-related excuse. So if they have, if they claim they have small children, well, they don't claim it, they do. If they have small children and they claim they're concerned about their children getting sick, the courts aren't going to argue with them. More commonly, if they're elderly, the courts are going to be very sympathetic to them. The courts are not going to, in fact, the civil code allows tenants to cite COVID-related reasons for breaching the contract, including not paying the rent. Right now, a tenant doesn't have to pay rent if, in fact, they are financially impacted by COVID. They are not excused from paying rent if they're just too cheap to pay rent or just don't want to pay rent. And that's what makes it sort of problematic. The tenant says, oh, I can't pay rent because I have a COVID financial hardship, but then they buy a brand new BMW. It sort of drives landlords crazy. But COVID-related excuses, whether it be monetary or health, are going to be forgiven for breaching the contract.
Okay, thank you very much.
Okay. So what is not in effect relative to laws, regulations, and moratoriums, and what is in effect? A lot of confusion, so I'm going to sort of clarify it a little bit. I'm not going to go through all the laws in great detail, but give you a pretty good overview. And then if you have a specific question, call me, because as I said at the live class I did a couple of weeks ago, I have got a file drawer full of information to guide you if you need help. I'm not an attorney. We would want your client to get legal advice, but I can give you a pretty good idea of what the attorney is going to tell your client. Okay, so what's not in effect? Well, first of all, you'll probably all know, and don't worry about this anymore. The San Diego County eviction moratorium went away earlier this month. It's gone. I think August 11th it went away. So that's not in effect. Don't even worry about it. Interestingly enough, only a few days ago, the federal eviction moratorium went away because the Supreme Court did rule that it was unconstitutional. I suspect the federal government will not appeal it because the moratorium was set to expire soon anyway. So the federal eviction moratorium has gone away. What is in effect? Well, here's the bad news. 4 state laws are either partially or totally in effect. Now, regarding these laws, some provisions are carried over from one law to the next. Some are modified by a later law, and some aspects of these laws are totally new within that law. But all 4 laws are still, to one degree or another, in effect. Like I said in the live class earlier this month, as I went through this, my head exploded, not literally, but figuratively. It takes a good bit to sort through all that. That's why there is so much confusion and so much wrong information out there. There is a lot of regulation to consider. And again, because this is not a property management class. This is a how do I sell a tenant-occupied property class. We're going to sort through this, and simplify it here this morning. Okay, so the 4 state laws, just a quick review. AB 1482, the infamous rent control and just cause eviction law, went into effect January 1 of 2020, and it's set to expire, I believe, I was going to look it up, I didn't, but I'm pretty sure it sunsets in 10 years unless extended. It'll probably be extended, but it's currently in effect. Now, the provisions that are favorable to many, many landlords have been temporarily suspended. So the provisions in this law that are sort of draconian are, in fact, applicable to all properties. And so 1482 is still very much a part of our situation, but some of our exemptions don't apply. And so that's important to note. AB 3088 went into effect August 31st of 2020, and it was set to expire January 31st of 21. SB 91 extended AB 3088 and added some new provisions. So it went into effect February 1st of 21, and it was set to expire June 30th of 21. Then along came AB 823. It's the law that is currently in effect, and it went in effect June 29th. And like I said, it extended the provisions of 91 and 3088. It also modified some of the less draconian features of 1482. And that is what's in effect now. And it's set to expire 9/30 of 21. Will there be a new law? Who knows? But as you can see, the state has passed 3 laws in succession, continuing with regulating and issuing moratoriums when it comes to evicting tenants. It's quite possible there'll be a new law to extend this current AB 823. There's nothing on the books yet, but that doesn't mean there couldn't be one fairly quickly. All right, so let's look at one aspect of the current regulations, and that's evictions for unpaid rent. So a tenant's not paying rent, landlord would like to get them out and sell the property. Since COVID came along, that's not too easy. Tenants have until 9/30/2021 to pay 25% of rent that's past due. Right now, tenants do not have to pay anything. Not a nickel. If they starting on 10/1, they have to pay 25% of what's past due. And if they pay the 25%, then they're immune from being evicted for non-payment of rent. If the tenant does not pay the 25% by 9/30, then on 10/1, supposed to be a slash there, on 10/1, the landlord could commence an eviction to recover possession of the property. Now, it's important to note that currently, under current law, an unlawful detainer is only prosecuted to get possession of the property, cannot be used to collect back rent. So since COVID, the unlawful detainer would only give the landlord back their property, but it would not collect the money that the tenant owes the landlord. To collect the rent that's owed, the landlord must sue in small claims court, a completely separate action. And the good news is the $10,000 cap is waived, so the tenant can sue for the entire amount of rent that the tenant doesn't pay on 10/1. So it can sue for all of it. Now, to succeed with an unlawful detainer action, and again, that is just to get the property back so you can put a new tenant in, or to sell it, you want to get rid of the tenant that's in there, they're not paying you. To succeed with that, the landlord must prove he or she applied for rental assistance. I'm going to talk about that in a moment. Okay, now, just cause eviction. So, can you evict tenants today? Yes, you can. I'm going to show you how it's not easy, but you can. A landlord can give a notice to a tenant to vacate with certain limitations. Now, currently, there are 10 at-fault reasons. The 1482, that first rent control law that was passed, contained 11 at-fault reasons. The one that's missing currently is the non-payment of rent. So before all these COVID laws, if a tenant didn't pay you, you could give them a 3-day notice to pay or quit, and then file an unlawful detainer action, and not only get them out of the property, but collect your money. They took away the non-payment of rent option. They left the other at-fault reasons to evict intact, but there are some limitations. And that is, as I was discussing, as Sissy asked, if the breach has a financial aspect to it, then you can't, or health, I should have put, or health aspect, then you can't evict for that purpose. For example, an assignment of a lease or adding a roommate without the landlord's permission is a breach of the lease, and under non-COVID circumstances could be reason to evict somebody. Not now. Why? Because the courts have ruled that assignment of a lease or adding a roommate has a financial aspect to it, and the tenant may have to do it because they're being financially impacted by COVID, and so they've got to have somebody help them pay rent. And so the courts will not allow you to evict somebody. Believe it or not, if they assign a lease to somebody, you can't evict them, or if they add a roommate. At this time, the at fault, as I said, does not include non-payment of rent. That was the 11th at fault reason. That's gone away. But you could evict somebody today for committing waste. So they're destroying your property. You can evict them. And but again, it takes time to get them out, unfortunately. You'll see that in a minute. Now, there are 4 no-fault reasons that exist today. Right now, you can evict a tenant. And again, it's hopefully a voluntary eviction. The tenant cooperates. There are 4 reasons you can ask a tenant to leave. One is, in the no fault, the tenant didn't do anything wrong, but the landlord has these rights. A family member move in. So my children, my grandchildren, my parents, or my grandparents, I could displace a tenant who's on a month-to-month rental with a 60-day notice to put my direct family in the property. I can remove the property from the rental market. I can give them a 60-day notice unless I'm in contract with a prospective buyer who's going to occupy the property, and the buyer is not a corporation. Then I could give them a 30-day notice. But otherwise, I give them a 60-day notice just to get out, and then I have the property vacant so that I can take it off the rental market and sell it in the sales market. If an order from a government agency to vacate the property, then that is a reason to have the tenant move out. Or if I rehab the property, but it is limited to habitability issues. And as the example I use is, before COVID, if I wanted to take my unit apart practically to replumb the entire unit because I have plastic piping and I want to put in copper piping, that might be a reason to evict the tenant because I'm doing a major remodel. It includes demolition, especially if it's an older property that might have asbestos-related environmental issues. That would be a reason to ask the tenant, if they're on a month-to-month, to leave the property. I could not do that today because the property is perfectly habitable with plastic pipes. So I can only evict a tenant and do a rehab if I have a habitability issue. The house has become, or the condo has become not habitable by the tenant without, a health hazard or something like that. So those are the 4 reasons. Now, for a no-fault just cause eviction, I must use the new form, the Notice of Termination of Tenancy, COVID Tenant Relief Act. It's the NTTCTRA. So if I want to put my property on the market, I want it vacant, a month to month with my tenant, and I want them to get out, I have to give them a 60-day notice, and this would be a 60-day notice, and I would use this form to get them out. Now, it's an important note. It's very important, especially if you're not the property manager. If you're the property manager and you've not done this, shame on you, because I've talked about it multiple times. last year. But I come upon a lot of agents who have clients who self-manage their property and don't have a clue that effective July 1 of 2020, the notice contained in an RCJC, it was required to give the tenant. So right now, all tenants should have received the notice of an RCJC. If you've not given the tenant an RCJC or your seller has not, the seller has to, before giving the NTT CTRA, must give an RCJC, then wait 30 days, and then give the NTT CTRA. And on the RCJC, lots of letters here, you check the box that the property's exempt. Okay. That's the new notice, the NTT CTRA. I'll include a copy of this notice in the PDF that I sent to Lindsay. It's a 3-page document. It has proof of service pages attached to it. All right, let's look at rental assistance. This is very important because it's perhaps a solution for some of your landlords. When dealing with tenants who are not paying rent, applying for rental assistance is a possible way for the landlord to mitigate their financial problems because the tenant's not paying rent. Perhaps better than trying to evict the tenant for not paying rent. You know, that's somewhat limited, as I explained already. Applying for financial assistance is a much more desirable course of action. Landlords today are recovering lost rent, 100% of the rent due the landlord that has not been paid by the tenant if they apply for rental assistance. Now, before a landlord can take legal action to evict the tenant for non-payment of rent, the landlord must first apply for rental assistance. So it's just, to me, a no-brainer that landlords who are complaining that their tenant's not paying them should at least apply for rental assistance. If the tenant's not paying them for a COVID-related financial hardship, the landlord will get 100% of the rent. If the tenant is not does not have a COVID-related financial hardship, well, then the landlord's application will be denied, but he needs that proof of application to take legal action against the tenant for the non-payment of rent. So rental assistance, from my perspective, is probably something all landlords should be looking into. Proof of application will be required by a court if you're going to evict your tenant. Now, rental assistance is available for unpaid rent from 3/1/2020 all the way through 9/30/2021, which is the end of the California eviction moratorium currently. If that moratorium is extended, it's likely the law will also allow rental assistance to be paid for that extended period as well. If the landlord does not apply for rental assistance, guess what? The tenant can. So if the tenant's not paying you and they claim a financial hardship and they ask you, why, you're the landlord, why don't you just apply for financial assistance? And the landlord chooses not to, well, then the tenant can do it. Now, to apply for rental assistance, the best, write this down or wait until you get the PDF, but the best website to go to is Housing is Key, all one word, housingiskey.com, or phone 833-422-4255. That will direct you to the right authority and it'll guide you on how to apply for rental assistance. The rental assistance is being administered by a couple of different agencies throughout the state, depending on where your property is located. And so to cut through all of the confusion, start with the Housing is Key website or make a phone call and get some guidance. There are other websites for information. Another one is housing.ca.gov. And in San Diego, the San Diego Housing Commission, sdhc.org. There's information on those two websites about getting rental assistance. And so, but again, start with Housing is Key. That's the best place to start. How is the money dispersed? Now, this is an interesting point that landlords should be aware of. If the landlord applies or cooperates with the tenant, let's say the tenant says, look, you're not applying, I'm going to apply. Well, then the tenant needs the landlord to cooperate ideally. If the landlord does not cooperate, the tenant can still pursue assistance. But if the landlord cooperates with the tenant's application, the landlord receives 100% of the unpaid rent for that period starting with March 20th of 2020. If the tenant applies and the landlord does not cooperate, guess who gets the money? The tenant gets 100% of the unpaid rent. And the landlord will not be able to apply for that same period because it will have already been paid out. Now, the tenant is supposed to sign under penalty of perjury that they'll give the money to the landlord. I suspect some tenants might not be forthcoming with that. So again, I would argue a landlord is behaving foolishly if they don't avail themselves to the rental assistance that might be available to them. You need that declination that, if they decline you, you need that to take legal action anyway. So you might as well do it and you might get the money. That's the nice thing. I've been asked this and I don't know from a tenant's perspective, but I can tell you from a landlord's perspective, it doesn't matter where you're getting the money. You'll pay taxes on your net just as if you would if the tenant gave you the money. So if the tenant gives you rent, of course, you deduct all your expenses and the profit you make, yeah, that's taxable. If the state gives you money, well, you deduct all your expenses. And if you make a profit, yeah, that's taxable. But there's no additional tax liability to the landlord for getting this assistance. Now, the tenant might, I haven't been able to determine yet, and I don't get a lot of tenants asking me, so it's not high on my priority list. The tenant might have a taxable event because they're getting the benefit of the money. So now they don't have to pay the rent because the state pays it. And there's no requirement for the tenant to pay the state back. So there could be a tax consequence to the tenant. But unless you're a tenant here on this call, you probably aren't too concerned about what is the tax consequence to the tenant. Can only apply for rent that is past due. You cannot apply for future months. So in the future, you can reapply for additional rent that goes unpaid and becomes past due. There's no limit to the number of times a landlord or a tenant can reapply. As months become past due, they can reapply and get additional monies. All right, let's talk about cash for keys. Giving a tenant cash or a check in exchange for the tenant voluntarily, that's the key word, vacating the property. Why would any landlord give the tenant money to get out of the property, especially if the tenant's supposed to get out anyway? Well, I can tell you why. The eviction process. That's why you might consider cash for keys. Let me review that with you quickly. In order to evict a tenant, you must first properly give the tenant notice. That can be, you're going to have to hire somebody to do that. That's not something an agent should do, and that's not something a landlord should do himself. You should hire an eviction attorney who specializes in providing notices to tenants pursuant to an eviction process. They intend to pursue an eviction process. Then you pursue an unlawful detainer action in court. You go to the unlawful detainer court, which is Department 60, and after giving notices and waiting the proper time, it's now 15 days, not 3 days, you can commence an action, an unlawful detainer action. So, the time frame's already being extended by COVID. All right. If the landlord prevails in unlawful detainer court, by the way, their workload is they're jammed up and they don't have as many courts hearing these cases. So it's going to take a while to get through the court. But once you get through the court, if the landlord wins, you'll get a judgment from the court. Now, with that judgment, you must process the judgment through the court to get what's known as a writ of possession. Quite a bit of paperwork, from notice to writ of possession. And as I'm going to show you in a minute, that can easily take more than 2 months, maybe 3 months, just to get you rid of possession. What does that do for you? It's a document that says you have the right to put the tenant out. You do not have the right to physically go over there and change his locks. It's against the law. You can get the sheriff to do that for you. So you take the writ of possession to the county sheriff. The sheriff immediately posts a 5-day notice to vacate at the property. If the tenant gets out in those 5 days, yay, you got the property back. If the tenant ignores the notice, then after 5 days, the sheriff will go to the property and do a lockout. The sheriff has up to 6 months by civil code to do the lockout. And currently the sheriff is waiting 2 to 3 months to do lockouts. So you're 2 to 3 months just to get the writ of possession. You're 2 to 3 months to get the property locked out, to get the tenant locked out. So you can see the eviction process isn't a very viable alternative today. Cash for keys is. Cash for keys saves you time. The court eviction process, like I said, 2 to 3 months easily. The lockout process, like I said, 2 to 3 months easily. You could be 4 to 6 months just to get the tenant out. In the meantime, a cash for keys would save you money because in the meantime, if you spent legal fees to evict, a minimum of $2,000 is probably what you'd have to pay. And it could be upwards to $3,000 or $4,000 if the tenant files certain notices or defends the reason they don't think they can get out. It's going to get even more expensive. And the loss of rental income. Most of the time when a tenant's being evicted, they stop paying rent. And of course, under the current law, they're not even required to pay rent. So if you have a $2,000 a month unit, you could easily, it doesn't take a rocket scientist to figure out, you could easily be at, $6,000 to $8,000 in lost rental income. So you're looking at $10,000 to get a tenant out in the current atmosphere that we're in now. A typical cash for keys arrangement, the tenant will vacate often within 1 month, sometimes by the end of the month. Now, probably, today it's the 1st, I believe, isn't it? So by the end of September, they might agree to get out. So it'll take you 1 month. If you served it to them, if you can't serve them, if you agree to a cash for keys in the middle of the month, they might, stretch it to the end of next month, a month and a half, but that's still better than 3, 4, 5, 6 months. They vacate in 1 to 2 months typically. The cost of the landlord generally hovers around 1 to 2 months rent. It's going to be hard to to entice a tenant to take a cash for keys offer if you give less than a month's rent. A month's rent might be the minimum. 2 months, I've had several people tell me that they've had to go to 2 months to get the tenant out. But again, if you have a $2,000 a month property, that's only $4,000 as opposed to $8,000 or $10,000 trying to go through the legal channels. Now, the terms would be negotiated. You want how much money will the tenant be paid? What's their move out date? And if there's, if there's a condition of the property expectation, you might put that in there. Hopefully you still have the deposit to use against the condition of the property. And so you keep that out of the cash for keys agreement. I'll talk about that in a second. And when and how the money will be paid. Sometimes the tenants will be a little skeptical. They're going to want a cashier's check. If they're going to move out, I'd give them a cashier's check, but you don't hand it to them until the proper time, of course. Now, negotiating tips. You should be fair and reasonable because the tenant has lots of options not to cooperate with you. So you're not going to get away with it, as the phrase says, on the cheap. That's probably not going to be successful. So be fair, be reasonable. Otherwise, it's not going to work. Don't come in too low. $500 cash for keys, probably not going to be successful. And the problem is if you start low and then start going up, pretty soon you have a tenant who wants $50,000. You started at $5,000, you went to $1,000, okay, $1,500, okay, how about $2,000? Meanwhile, they're thinking, okay, let's go to $25,000. So everything I've read and all my personal experience, start fair and reasonable. Don't start low, and then be firm. If you're going to give them 2 months rent, say, look, you want the 2 months, we got to do this. You don't want the 2 months, I'm going to go to court. So be firm. Don't let them walk you up from a reasonable, fair offer. Now, cash for keys or agreements does not absolve the landlord from his or her obligations regarding the security deposit. So you must account for the security deposit within 21 days of termination of tenancy. And here's a little tip. I shared it before. Sometimes these tips can be pretty valuable. Often you don't get hung up on this, but you should be aware of it. Security deposit, to collect on a security deposit, the code requires you must have actual damages, not anticipated damages. The code doesn't allow you to deduct from your security deposit what you think your damages might be. What does that mean in English? That means technically you should not be deducting the cost of replacing a carpet that they ripped up based on an estimate. The cost of replacing the dishwasher because the children climbed up on it and broke the door off, and they used the wire baskets for I don't know what, and it's completely ruined. So you have to replace the dishwasher, and you get a quote for how much that'll cost. You can't technically, legally, use the estimate as in your accounting. You have to have a paid receipt. So just keep that in mind. If you pay in advance, you're using vendors you trust, now you've got a receipt. That is your actual damages. The work doesn't have to be done, but sophisticated property managers are very much aware that if the tenant challenges your accounting and they go to court, the judge is not going to allow you to present estimates. They're going to want to know how much money have you spent right now? How much money? Or within that 21 days, because you're not going to get there within 21 days. How much did you spend by the end of that 21 days? Because that's what they're going to look at. Okay. The security deposit should not be mixed in with the cash for keys agreement. That's just a little tip. Okay. Cash for keys process. 1, explain the situation to the tenant and the potential negative impact to the tenant. The tenant doesn't care about your problems getting them out. They just care about their problems if they don't get out. So talk about the negative impact on the tenant's credit report if you do an eviction. Talk about, I'm selling it. It's going to be inconvenient and you're going to move anyway. I've given you a notice. You're going to have to move. Why not, take this money and use it towards your move? Suggest an alternative. Cash for keys. Agree to the terms. Most importantly, the money and the move out date. Be present at the move out. Why? Because you want to execute the cash for keys satisfaction addendum. And you want to change the locks once the tenant is, in fact, out. There's lots of horror stories where the tenant took a second set of keys, moved back in, and, now you got to start all over again getting them out. There's a cash for keys agreement in card form. It's really pretty good. It will work. It suffices. It'll accomplish your mission. What's not in card forms, and I joke, but I don't joke, I guess, I'm going to suggest to the forms committee that they come up with a cash for keys satisfaction of addendum. You want to memorialize that the tenant has agreed to the cash for keys agreement and that you've paid them the money, and that the tenant, this is important, that the tenant has completely vacated the property. Because once they vacated the property, if they move back in, they don't have the same tenant rights they had prior to vacating. That's a technical point in the law, and that's important, that when the tenant does move out, you have them, acknowledge that in writing that, yes, I have moved out of the property. Okay, that's good. You can't move back in. All parties agree that the agreement has been fulfilled satisfactorily. So that's the basic information contained in the cash for keys. So as you can see, the alternative to the cash for keys, going through a legal process of evicting the tenant, can be costly and time consuming. A cash for keys is a great alternative. And in the meantime, apply for your rental assistance to even further minimize your damages. And that way you're not as damaged by the current COVID situation by tenants who aren't paying you. Some probably are legitimately financially impacted and have problems. I hear a lot of horror stories where the tenants are just taking advantage of it. So you do have some alternative courses of action to protect your landlord clients. All right. Lindsay, do we have any questions in the chat?
Yeah, Anne asks, what do you do if the current property manager will not provide the current rental agreement?
You have the landlord ask for it. And then see the problem that sometimes you have when you're the listing agent, but not the property manager is mad because they don't have the listing agreement. So the property manager, one would argue, should cooperate with the listing agent, but they're not going to be as inclined to do it as they are with the landlord. So you tell the landlord, look, get a copy and demand it, put it in writing. And the landlord, not you, the landlord says, failure to do this will cause me to seek the advice of legal counsel and to contact the DRE. A principal failing to provide a copy of a document, an agent failing to provide a copy of a document executed by the principal is a serious infraction of civil code and DRE regulations. For example, you fail to give your seller a copy of the listing contract, that listing contract is invalid. So anyway, the short answer to your question, Ann, you shouldn't be the one asking for it. The landlord should, and he may have to put a little teeth in his request. You can coach him a little bit on how he phrases it, but he gets it, and then he gives it to you.
The next question is statements from Greg Alexander, and he says, from my understanding on rental assistance, the tenant must qualify lower income and hardship due to COVID and also requires the tenant's cooperation.
Correct.
So a landlord has to have the tenant's cooperation and can't do it without the tenant's cooperation.
Greg's exactly correct. So so the bad news is if they don't cooperate, you're not going to get the money. That's a fact. Now, I would argue, why wouldn't you cooperate? Because I'm going to get the rent and I won't have to sue you for it. So I would argue that, depending on how, contrary the tenant is, it should be, couched in terms that the tenant might want to cooperate. A more important problem that's not, you can't get over is if the tenant's income isn't low enough. They have to, there's an income threshold. If the tenant makes plenty of money, then the landlord's not going to get the assistance. That's a fact. Okay. So there are some problems relative to the tenant and getting the assistance. More importantly, you can't evict the tenant if you don't have a denial. So you turn it in, you say the tenant won't cooperate, the tenant's income is too high, and they say, well, you can't have it, and they will issue you a formal denial. In fact, the law requires they make that available, ideally, practically by a website. Why? Because you need it, and the courts need to see it. So the paper trail will be there to protect the landlord from being thrown out of court because, hey, where's your rental assistant application? Well, my tenant didn't want to cooperate. Well, then I need a denial. That's what the courts are going to say. So Greg is correct, though. If the tenant doesn't cooperate or makes too much money, you'll end up not getting the money. It's kind of interesting. The landlord cannot cooperate and the tenant will get the money. But if the tenant doesn't cooperate, the landlord won't get the money. Well, folks, I thank you for joining me. I hope this gave you a little bit more insight into the situation we're in.